Hi, and welcome to another case in Legal Arena. Today I'm going to play a criminal case. So let's go ahead. I'm here on legalarena.app. So as of today's update, I've added the option to select which country's cases can be fought. So I'm going to select India because I'm Indian. So basically, what this does is it just picks the right client names, the party names, and also the flavor of disputes native to that country. For example, if you select USA, you might probably run into cases where there's gun laws involved, whereas in India, it could be dowry related or so on. Anyway, I'm going to start a criminal case now. I'm going to select criminal level one. I actually have some experience in level two and level three, but I'm still not confident about my ability to win cases. So I'm going to go ahead and start with the most basic kind, level one. Okay, so this is a case. Let's see what's going on. Imran will say that his case rests on a fast, stressful moment and a mistaken identification. He was in the area for work, but presence is not guilt. There is no recovery of the phone from him, no clear video of the taking, and the complainant had only seconds to observe a rider in a crowded evening setting. Okay, I don't even know what is happening. It looks like I'm a defendant here. I'm representing the defendant, so I'm gonna ask him what's going on. Okay. Hi Imran, what's going on? How can I help you today? Tell me everything that happened. I'm a delivery rider, and that evening I was near the station waiting for my next order. I got into a brief verbal exchange with an auto driver about parking space, but that was it. I never touched Ria, and I never took her phone. After delivery notification came in, I left and rode towards House Rani for the order. Later on, police contacted me because someone had noted part of my bike number. From my side, I think she connected me to it because she had seen me nearby already. A lot of riders around there look similar with the same kind of delivery bags and helmets. I was there around the same time, yes, but I didn't steal anything. A lot of ranting going on, so I'm going to ask him what he's accused of. I'm accused of snatching or stealing Ria's phone near the station. Okay. Mm, did the police find the phone on you? No, they did not find the phone on me. So, I'm gonna ask Imran the actual truth and see what angle I should defend him from. Because in criminal law, unfortunately, sometimes you have to defend your client in such a way that they get the least amount of punishment possible. So let's see. Tell me the truth. Did you steal the phone or not? I'm asking not to trap you, but to figure out how exactly I can help you. If you did steal the phone, I can convince the judge to give you a reduced sentence. He did not steal the phone. So it looks like a classic case where the phone was stolen or lost, but everybody thought he stole it. Now, this happens a lot in India, especially if you are working in the service industry, like a delivery driver or something. People mistake you for being a crook. So, what else do we do? Ha ha ha. Do you have any prior criminal record or pending cases? No, I do not have any prior criminal record or pending cases. Okay, cool. So this guy just happens to be in the wrong place at the wrong time. Was there any CCTV recording of anything, any part, any before or after? The reason I am asking you is so that I can study your demeanor and demonstrate to court that you were not on the run. Okay, he does not have any CCTV footage. I'm going to review the timeline once again, okay? After delivery notification, he rode towards House Rani. That's it. Okay. Cool. Let me open the history and see what else had he said before. That evening, I was near the station waiting for the next order. I got into a brief verbal exchange with an auto driver about a parking space, but that was it. I never touched Rhea. I never took her phone. Okay. What is the connection between the auto driver you had an argument with and Ria? As far as I know, none. I only had a brief parking space argument with the auto driver, and I believe Ria later connected me because she had seen me nearby. Huh. So it looks like there was no connection between Ria and the auto driver. The altercation with the auto driver is also somewhat immaterial, but I think it might help him because a thief that's on the run will not stand and argue with an auto driver, right? Huh. But the auto driver is definitely not going to testify in your favor if he doesn't like you. So, what else do we do? What else do we do? Do you have, yes, what app are you a delivery rider, delivery partner for? I was doing app is early work, but I'd rather not name the platform unless it's necessary. Okay. Do you have location records of some kind from your app? Not that I know of. Will I be able to obtain them from your employers? They must have been tracking your movements during your shift, right? Not sure the platform might have that, but I don't have it myself. Okay. Um, what relief are you expecting from court? I want the allegation I took her phone to be rejected. Yeah. Uh, were you arrested by the police? Or is it just an accusation made privately? No, I was called to the police station later, but I wasn't arrested. Now, this happens quite a bit in India. You get called to the police station, and this is usually done to, intimidate people or show relief. I mean, like appease the other person, right? Without having to do any much, a lot of work. So, yeah, what likely happened was that Qureshi was called to the police station and he was given a scolding for something he didn't do at all. But then she seems to have filed a civil suit. Was an FIR filed. Ask that. Not sure. I was called the police station later, but I don't know if they actually filed an FIR. Okay, this is a fairly straightforward case where no FIR was filed. Mm, let's see what supporting facts are here. Brief parking space argument or auto driver only. No phone recovered. Complainant observed rider only for seconds. Rental history was normal with no prior disputes. Prior to similar disputes. No known CCTV identified by client. No known connection between auto driver and RIA. App-based delivery work at the time. Denies prior criminal record of pending cases. Okay. He was also not arrested, so that's a huge one, right? Okay. I think it's a fairly easy case to win because the police didn't arrest him. He was not arrested. He was not formally arrested. So this is not a criminal dispute. It's a civil dispute. But let's see what the court says. Okay, so Ria Menon made an opening argument, or the counsel for Ria Menon made this opening argument. May it please the court, Ria Menon's case is simple. She reported the same evening that a phone was taken near Malviya Nagar Metro exit at about 7:20 p.m. by a rider carrying a delivery bag, and her written complaint recorded a partial byte number ending in 4821. That prompt specific complaint matters because under the rule that reliable records beat vague stories, a contemporaneous written report is far more trustworthy than a later blanket denial. We do not overstate this record. The complaint by itself does not answer every question, but it firmly supports 2 points that matter at the start of this case. This was an afterthought, and Ria identified a delivery style driver at the place and time she described. She had no reason to falsely accuse a stranger, and we asked the court to recognize that her phone was taken from her and to hold Imran Qureshi accountable for that basis. Um, okay. So I'm going to make the following argument. So basically, I'm going to tell the court that he was not arrested, there was no FIR or charge sheet filed. So what crime is he even being tried for? Your Honor, my client Imran was not even arrested by the police. All that happened was a mere summoning. He went to the police voluntarily without an arrest, and there were no FIRs or charge sheets filed against him. So this is not even a criminal case. The procedure is not followed properly, and on that ground, we would like to say that this dispute should be quashed. Okay, I'm going to present this argument. Let's see what happens. Okay. The judge signal says that the opponent had a stronger round because counsel answered the procedural point directly and returned to the court the interpreter's complaint and identification record, while the defense overreached beyond the visible record and FIR and charge sheet status. Okay, looks like there was a charge sheet. Uh, or I don't know. Was there a charge sheet? Let me see. Your Honor, the absence of an arrest does not answer the question before the court because under the burden of proof rule, the issue is whether the record supports that Ria's phone was taken in the manner she reported. Her complaint was made the same evening. It fixed the place and time and recorded delivery style rider with a partial byte number ending in 4821. So defense point about police procedure does not displace a contemporaneous complaint or the matching rider presence at the scene. We ask the court to keep the focus on that identification record rather than treat a non-arrest as a finding that nothing happened. Okay, let's see. I want to tell them that this is a criminal case and it requires beyond reasonable doubt that he did steal the phone. In this case, there's no evidence. All there is a delivery style rider and a partial matching number, the license plate. Okay, so that's what I'm gonna argue. Your Honor, this is a criminal case, and criminal cases like these require proof that has to be proven beyond any reasonable doubt. And in this case, yes, we no doubt acknowledge that um, she saw a delivery style rider snatch a phone and the number plate partially matched. But I'd like to also challenge using the facts that A, no phone was found with my client Imran. B, someone on the run wouldn't be wasting time arguing with an auto driver over a parking space, which is what happened. And C, he wouldn't come to a police station. No, a thief like that wouldn't come to a police station when called by the police. Um, he has no obligation to come to the police station, but he still did. So, based on these three, it's entirely possible that it was a classic case of mistaken identity. Besides, the police didn't do its job investigating the case or taking down the complaint. They just called my client to harass him, and then the harassment is getting piled on him. Okay, I'm gonna submit this now. Presenting. Okay. Oh fuck. Uh, this round was closer. Your side improved by shifting to mistaken identity and using the lack of recovery, but the other side still had the stronger response because it stayed tightly on the identification record already in evidence and answered your new theory without leaving that lane. Okay. Their argument. Again, they are reiterating that. Okay, let's read this out loud. Your Honor, the defense now accepts the central point that Ria saw a delivery style rider take the phone, and the only question they arise is identity. On this record, that issue is still answered by the same evening complaint, fixing the time, place, and partial bike number ending in 4821. Under the rule, that identity evidence must be assessed for reliability. The court can give weight to a prompt identification made in the moment rather than a later denial unsupported by any record. No recovery from Imran and his later appearance at the police station do not erase the identification record. The court should keep the focus on whether Ria promptly and consistently identified the rider who took her phone, and this record suppose that she did. Okay, there are procedural problems. There are, which is of course the police station didn't even file an FIR. Um, no, the other side is just putting pressure blindly. What do I do? How do I even argue this? Focus is round. Mistaken identification among similar looking delivery riders. Denies touching rear or taking phone. Brief parking space argument with auto driver only. So, Your Honor, there are hundreds, maybe thousands of delivery riders in the vicinity. Delivery apps are very popular right now, so it could be anybody. And secondly, my client denies touching her or taking her phone. Uh, I don't know what interaction they both had, Your Honor. It's not on the record, but it's not my client who did it. And if we are to establish that my client is guilty, we need to go through a proper procedure, which involves police investigation. That is my request. Okay, let's see. Oh no. Okay, I lost this round. The court rules against your side on the present record. In this criminal dispute, Rule 1 and Rule 41 require the accusing side to prove the essential elements with specific evidence, and Rule 42 requires caution with. Here, the other side did present a same evening written complaint fixing the time, place, delivery, rider, and partial bike number ending in 481, which gives the accusation some reliable support. But your side showed meaningful caution points too. The observation was brief, no phone was recovered, and no stronger confirming records such as clear video or location data was produced. Even so, your argument did not supply enough record-based material to displace the prompt identification, and the court is not persuaded to reject the allegation outright as you requested, because your requested relief was complete rejection of the phone taking allegation. and the visible record does not support that full defense ruling. The legal result goes to the other side. Hmm. Maybe what happened was that the investigation was ordered. Hmm. Cool. This is another case lost. Okay. Bye.